I'll ask whether I have Ms. McCafferty present. Mr. Havens, have you heard anything from Megan?
No, I haven't.
Okay, so what I'm going to do in this case is just confirm with you. When we were here last, we were still working on service to the other party. I note, though, that this court previously issued an order of default for lack of any response from Ms. McCafferty. So although you have served her, whether or not that was totally necessary, I guess neither here nor there, since you have served her now. Also, you did meet with the courthouse facilitator to review your orders, and I have the certificate from the courthouse facilitator showing me that that has been done and that these orders are ready for my review. I have reviewed them, and it does appear that the orders are ready for my signature. Is there anything you're asking the court to do, or any questions you have beyond what you have submitted to the court?
The only thing I have to say is last time I did talk to Mrs. McCafferty, she said that she was recently put back on Spousal. So that leaves me to believe that she's recently used again. So
Does that in any way change any of your requests for the parenting plan or a protection order or anything like that?
No.
Okay. So what I have done, I will sign your orders. I find that they are appropriate. I also would note that I'm gonna, with regard to the parenting plan, based on my review of the file, Ms. McCafferty's failure to meaningfully hear in this case, and the information I've reviewed, I will find that a parent, Ms. McCafferty, does have some limiting factors under 3A and 3B. Under 3A, I will find that neglect is present on behalf of Ms. McCafferty, as she has substantially refused to perform her parenting duties. Under B, I will find that neglect and substance abuse is more likely than not present on behalf of Ms. McCafferty, as well as emotional problems that do seem to get in the way of her ability to parent. So I will put those in order. Because of my finding under 3A, I do have to limit her time with the children. You have laid those limitations out in your order, and I will adopt them. Any parenting time would have to be supervised. The indication in the order, Mr. Havens, and I just want to clarify, is that you would have to be present when she is with the child. Is that correct?
correct.
Okay, I will keep that in the order. I think that's appropriate. I will order a drug and mental health evaluation. And then I think what you've indicated in here is that if they don't follow the evaluation or treatment, then only supervised visits for 4 hours on a Saturday. Is that your request? Is that yes? Sorry.
Yes.
Oh, there you go. Okay, because of my findings under 3A and B, I am indicating that major decision-making is limited. I will find that you are the primary parent for purposes of school and educational decision-making. You have checked joint for healthcare. Is that how you're wanting to proceed?
Oh.
Well, means she's not really that communicative. It'd be easier if it's just me, but if anything like happens, I will still notify her if the daughter goes to the hospital or something like that.
I am going to change that, just given, again, her lack of meaningful participation in these proceedings and my findings under 3A and B. So I will make that change. Okay. Okay, I think everything else you have filled out. So besides those issues, anything else you want the court to know?
No, that's all I have to say.
Okay. I'm just going to take out the proposed language and click the box. This is a court order. So if there's nothing else you need from the court, you are free to log off.
Okay, so I can get the copy of that at the receptionist desk?
Yeah, let me just ask, I know in some other dockets, we kind of make these available pretty quickly, but how should he come back tomorrow for copies of these, or are they usually ready today?
He can, I can ask today from him.
Are you sure? Okay, let me just finish signing where I need to sign, and then the clerk has indicated she'll have someone come into the courtroom and get these signed copies. So maybe hang out for 20 minutes or so.
That would be wonderful.
Make sure I sign everywhere I need to a little bit, and we'll get copies for you.
Okay, so if she doesn't get a hold of me on Saturdays, then I don't have to worry about it then?
Yeah, I mean, I definitely think, given again her lack of any meaningful participation in this case, the burden's going to be on her to reach out and request those visitations. The order allows it, but if she doesn't show up or she doesn't adhere to the evaluations we've requested, then the burden is not upon you to force her to do it.
Thank you.
Okay, thank you for having those ready for the court.
Have a great day.
Thanks. So when we were here last, I denied Ms. Steinwig's motion for default because Mr. Olson, you did appear, but I gave you a deadline of today to file your parenting plan response. I haven't seen anything come through.
I'm
Where?
sorry.
Go ahead.
I did turn in some paperwork today. Your Honor, I've had the hardest time. It seems an attorney would have been great for me. I mean, even yesterday, I came in yesterday to turn in my paperwork early. I had to attach some attachments, and when I went to go get them printed, the Wi-Fi wouldn't work and I couldn't get them printed. And it's like one thing after another has with the case.
Did you, so just to check in, did you file your response to the parenting plan today?
Yes, this morning. I was here first thing this morning.
Okay. Sometimes, and that you would not have any reason to know this, but sometimes people will provide what's called a bench copy. So, because it's going to take about 4 days for me to wait for it to be digitally scanned in. So I don't have any way to see what you have filed. So what people will do is provide the clerk with a hard copy saying, give this to the judge. That way I have it in front of me for today's hearing.
Yeah.
I assume you didn't do that.
No. You know, I apologize. And it just seems like that I should have had a copy for Tiffany to have, you know,
Well, so that's my next question is you do have to serve Ms. Steinwig with whatever you're filing with the court.
Okay.
I will give you some additional time to get that done, but I know I don't want to keep taking up Ms. Steinwig's time for your failure to get these things done on time.
I am so sorry.
Okay. When can you get her copies of the documents you have filed with the court?
Today, I mean, absolutely, I can today. Now they live quite a ways away. I could email them to her, I guess. I could do that, yeah, or text them to her.
Well, let me ask Ms. Steinwig, because we presume personal service, but Ms. Steinwig, would you be willing to accept email copies of these documents for purposes of moving this case forward?
Your Honor, at this point, last week he was given a date and told that if he didn't follow through, that we would consider default.
Correct.
And at this point,
But that's not my question. He has filed his answer with the court. My order says he has to file it by October 4th. He did that. I'm not saying that he's done a great job, but I'm saying he met the bare minimum for avoiding a default. And he
I
is,
will accept them however I can get them.
okay, what is it? Does he have your current email?
I don't, it's the paperwork, but
I can just text it to you if you,
I don't
I'll
know.
send you my email address.
Okay, that would be great. So Mr. Olson, if Ms. Steinweg's available next week, I'm gonna set this over 1 week. That'll give me time to review your response. You'll have made service on her, but then we really are moving forward, because I absolutely understand Ms. Steinweg's frustration with what is happening here. We can't.
I understand.
Done the bare minimum to avoid default, but that's not saying too much, okay?
So, I mean, really, we could probably resolve it right now. Like, I could tell her, what I have done, and what I'm doing now. And I know that she was really concerned because the judge wanted me to take a hair follicle, and I have been going into debt. Like, I lost my job in December, and unemployment ran out, and I had to have emergency surgery on my leg, and I can't work, and like I'm struggling so bad financially that another $350 for a hair follicle. And Your Honor, I will admit to that after 14 years, I relapsed. After I lost my job, I got into a funk, and I relapsed. And when they admitted me for my emergency surgery in Portland on my Achilles, that was it. That was July 22nd. That's the last time I got myself into outpatient treatment. I'm still in.
So back on August 1st, you were ordered to submit to a hair follicle test, or excuse me, back in July, you were ordered to submit to hair follicle testing. And then by August 1st, a judge issued a ruling that you had failed to appear at the July 21st hearing, that you had not provided results of the drug test. So the court presumptively found that those results would have been positive. Have you done a hair follicle test since August 1st?
No, I have inquired on one. Like I said, it's $350. And really, I didn't know they need an address to send it to. And I don't know where I would put down for them to send the results to. I will go get one today. It's not as easy as it sounds. But like I said, I'm going to end up paying for it, and I really can't afford another $350, but I would absolutely go do that if that's what you're.
So, well, I mean, it's not what I ruled, it's what another judicial officer in this county has already ruled. I'm not going to overturn that. That's still an outstanding obligation of yours.
Okay.
But let me just ask you this for purposes of moving this along, so we know what we're doing next week. Are you objecting to the Ms. Steinweg's petition to modify the parenting plan?
Yes. She wants me to only get him every other weekend. I'm not going to do that. That's not enough.
Okay. Well, I will review that objection when it isn't. I'm assuming that's what you have filed with the court, is your statement regarding your objection to her request. Is that correct?
Yeah, I wish.
I will review that. We will hold a hearing on that issue next Wednesday at 9 a.m. I would tell you that, again, I'm going to reiterate that your obligation to get hair follicle testing is still an outstanding obligation. Failure to do so leaves the court with no option but to consider that your failure to do it means the test would have likely been positive. So.
Well, I'm admitting that I relapsed. I mean, why? I mean, you just want it on paper, and then for me to go $350 more into debt that I don't have doesn't make sense to me, but that's okay. I'll do it.
Okay. Ms. Steinweg, are you available next Wednesday? And again, I understand your objection to another set over, and I understand your frustration with this process, but we will move forward next Wednesday.
I am.
Okay.
I apologize.
We will see you both back 9 a.m.
So I
next
have you
Wednesday, both on for an adequate cause motion and a review hearing. So let me just get into this file. And then Ms. Looney, I see you're also present on this case.
Yes, Your Honor. We only discovered that this case was on for adequate cause, as well as the motion to adjust child support on Monday when this case appeared on the docket. We were not served with anything. So at this time, the state is requesting a set over as for the child support portion to November 1st.
And I think that makes sense. I have some other concerns regarding the adequate cause motion, but based on that request, I would be inclined to give the state additional time to review this matter, to give input to the court. Mr. Lawrence, any input from you on that issue?
None on the child support, Your Honor.
Okay, well, yeah, well, let's take that one first, and then I'll come back to the review portion of this case. So Ms. Gutierrez, any objection?
No, I don't have any objection to that.
Have you been served the adequate cause motion?
So I was served, but I really didn't understand it because like all of his paperwork says that I'm the petitioner and I'm not the one petitioning.
Yeah, understood. Mr. Gutierrez?
Yeah.
So I think as you're hearing, you have filed a motion for adequate cause to adjust child support. The state has to be involved in that process, and they only recently learned of your request. So they are requesting a set over to November 1st. I am inclined to grant that. Do you have any objection?
May I ask, well, what do you mean by that?
Meaning you filed a motion to change child support, but first I have to find there's adequate cause to do so. So you did file a motion for an adequate cause decision. Instead of making a decision today, I am going to move that issue to our November 1st docket. So you'll log back in 4 weeks, November 1st at 9 a.m. And then we will discuss that issue.
Okay.
Okay.
So meanwhile, I'm just stuck without pay and just deal with the consequences of barely having enough money to eat and stuff.
I'm sorry. I can't make out what you're saying. Can you repeat yourself? You're kind of in and out of audio.
I'm saying just meanwhile, I'm just stuck with whatever I get as income and just deal with it.
So I'll rephrase it differently than you. What I will tell you is that there is a final order of child support just from 2022. So you, up until I make a further decision, are bound by that 2022 order for child support. Yes.
Okay.
If you want to phrase that differently, feel free, but that's the court's ruling.
No.
Okay.
Okay.
Okay. So then let's move on to the review portion of this. And I'm just going to pull up my notes. So Mr. Lawrence, I guess I'll turn it over to you. I think if my notes are correct, the review portion of this case really involves Mr. Gutierrez and his evaluations that we're wanting to get done and see.
That's correct, Your Honor. I had a chance to speak with a representative of the Kaiser Outpatient Substance Abuse Program. And what she indicated to me was that Mr. Gutierrez was declining or not admitting that he needed any treatment. And I explained to her the court process and that we had requested input for myself and Ms. Gutierrez as well. And they indicated to me that as long as he is declining treatment, regardless of our input, that they are not going to put him through treatment. And so my understanding is that Mr. Gutierrez is no longer living with his sister, which he was at the time of my last report. He apparently lived with a girlfriend for a period of time, but is now basically floating and living with friends or in his car or whatever. And that was indicated to me by an email from Mr. Gutierrez here about a week ago. And so we have a situation where essentially he's homeless and is refusing treatment. And his alcohol issues are kind of the heart of the issues in this case. And he has had no visits with his children as an incentive for him to get into treatment. And now apparently he's refusing it. So my only recommendation at this point is that the status quo be maintained until he does get into treatment and starts trying to improve his life.
So thank you, Mr. Lawrence. I appreciate that. Mr. Gutierrez, I want your input, and I'm, looking back through the order, the history of this case and the order that a prior judicial officer entered, suspending visitation, pending drug and alcohol evaluations and treatment. So, I'm not inclined to make any changes to the suspension of visitation, but I would like to hear from you and get your input on this issue.
I have not declined any sort of treatment. I conversated with the counselor.
Hold on real quick. We're having the same problem. I am not able to pick up your audio well enough to understand what you are saying. Can you try to?
Give me 1 second, then.
That's better. Whatever you just did is way better.
Oh, okay. I have not declined any sort of treatment or anything at all like that.
You just kind of cut out again.
Oh my God.
Can you stay close to the microphone on whatever device you're using?
Can you hear me?
Yes.
Okay. I have not declined any sort of treatment or anything like that. I spoke to the counselor. I did what I was supposed to do. I'm just waiting around to hopefully get my visitation time with my kids. I mean, I missed the whole summer because of this.
Right. So are you engaged in treatment with Kaiser?
Not at the moment. I mean, I like I said, I've talked to the counselors and they asked me to do drug tests and stuff like that. And I'd done them all. If Mr. Lawrence or Alisa haven't received those results, I don't know what to tell you, because I have reached out to the counselor to email those to them as an evidence, and I just out of my hands, I guess.
Well, so here's what I would say. It's not out of your hands because this is your life, nobody else's. So it is, if the counselors are not sending reports to Mr. Lawrence, then I recommend you go get those reports from the providers and you get those to Mr. Lawrence. Because what I am telling you is I'm not going to make any changes to visitation until I see that you are in compliance with your evaluations and treatment. Okay.
Well, like I guess I just have to talk. I wasn't told to go on any kind of treatment or nothing like that. So I'm not denying to go into treatment at all. I'm just saying I did the evaluation like I supposed to. I mean, yes, it took a little longer than I expected. But I don't know what to do from now. I don't know what to do now.
Yeah, what I'm telling you specifically to do is we're going to, since we're already coming back November 1st, I'll set another review date for this issue to November 1st. And so that gives you 4 weeks for you to proactively reach out to Kaiser about getting paperwork to Mr. Lawrence and or getting engaged in treatment and or getting drug test results to Mr. Lawrence. Because right now he's being told is that you're not engaged in any sort of treatment with them.
I mean, I don't feel like I need to. I mean, honestly, what do I?
Yeah, so Mr. Gutierrez, if that's your position, then we'll address that November 1. Just know that if Kaiser is stating that you're refusing treatment, I will take that into account when I make a decision about your visitation rights with the kids.
Okay, so what do I need to do? Do I need to go take drug tests and have those emailed to Mr. Lawrence? Is that what
what you need to do is reach out to Kaiser. You need to follow whatever treatment plan they have for you or whatever request they have for you, and then get that compliance notation to Mr. Lawrence, either through your counselor or by you taking the paperwork yourself from Kaiser and getting it to Mr. Lawrence. Okay? Okay. Elisa, any input from you?
Not really. I mean, I didn't know where all the new paperwork came from because we still had this current case open. So that's why I am just here to figure out why he's trying to re-petition the parenting plan. And
we will, I have looked through that motion. We'll address it on November 1st after the state looks at it.
okay.
But yeah, we'll just essentially reset both of these issues to November 1st and see.
Okay.
That. Okay.
Sounds good.
Okay, Mr. Lawrence, anything else on this matter?
No, Your Honor.
Okay. All right,
When
Mr.
we were
Gutierrez,
together
you're on the 23rd. Looks like we did go ahead and put into place the temporary parenting plan. And then we set a review date for today. Let's see. I'm looking at this affidavit. There was incomplete documents that were not able to be filed. So I guess, Mr. Lawrence, I'll turn it first over to you.
Your Honor, this was a matter where Mr. Utter had been out of his son's life, Parker, for a number of years, and is now trying to reestablish a relationship with him. And he and Kirby were working together to accomplish that, and things were going well. The two of them got together and created a parenting plan whereby Mr. Utter started out with Saturday day visits and could have Wednesday evening visits with Parker, and everything appeared to be going very well. I spoke to both the parties yesterday or the day before and found out that those visits have fallen apart. And from Kirby's perspective, apparently she feels that Stevie has just failed to enact the visits and has missed 4 of them. From Stevie's point of view, there was maybe some scheduling issues, and that he feels that maybe Kirby is trying to undermine the visitation. Stevie had gotten Parker signed up for football, and now Parker's refusing to play. And so right now, those visits are not taking place. And I'm not sure exactly what happened, but all the wheels fell off.
So let me start with you, Ms. Young. What's happening with those visitations that I think we had just adopted those back in August in the temporary parenting plan?
So I have reached out on several different occasions with Stevie to schedule visits. And I have made note of every time, say it was, I think both of them were Saturday visits. He was supposed to take Parker to lunch. He just never has showed. He's called Parker one time since our last court. He seems to think that I need to reach out. I have reached out, but he doesn't follow through and show up. I had talked to Keith yesterday. I think that I was asking Keith his input on, does Parker have say in this? I know where Parker stands as far as what he's wanting from the relationship with Stevie. He doesn't seem to follow through. He's got a lot of excuses, I had to work. I was sick. Family issues, he has claimed. I don't know what more I'm supposed to do. I've went above and beyond what I think is fair to try to make it happen. I can't make him show up to the visits. But I'm the one that has to explain to Parker, he didn't show again. And it's unfair. They don't have that type of relationship there's not enough of a relationship there for him to be this way with Parker.
Right. Okay. So Mr. Utter, give me your take on this situation as it pertains to visitation and what's going on.
Okay. As far as visitation, we agreed together. We went in together to sign the parenting plan uncontested. Everything was going fine. Parker came over for my daughter's birthday, had a fabulous time, played football games, poker, did very, very good with everybody. I'm sorry, I'm getting a lot of feedback. I don't know if you can hear me or not.
I can, yes.
Okay. Everything was going good. We agreed on that. We agreed on counseling for him. When it came down to it, I just needed his Social Security to get him on my insurance. Had reached out to the counselor that the court had provided at one time, but couldn't do it without Parker's insurance. She's refused to give me his Social Security number to put him on insurance. She thinks a school counselor is adequate for this type of thing, and I don't agree. He needs a
Not
counselor
true.
equipped. I'm sorry.
It's okay. Ms. Young, I'll come back to you. Go ahead. Ms. Young.
I tried to start the visitations that we had implemented together for the courts. It never came to fruition. I called, tried to schedule things. The appointments that she's speaking of, there was never any appointments that I'm aware of. Parker did kind of pull back a little bit. Before the papers were signed for the last time we were at courts, we still agreed to go through with everything. She had still signed the papers, everything else. I don't know here what the change in Parker's behavior was. Like I said, he was very, very excited. He was good for the birthday party. After the birthday party, I'm sorry, prior to the birthday party, signed up for football. He had called to ask to get a mouthpiece, socks for football, took him out to lunch, did this, came home, boiled his mouthpiece, everything fantastic. Spent the entire day and the entire evening, and that's the last I've seen him was early August prior to the courts. Since then, Miss Young went to get his gear, I suppose, for football. Parker didn't know how to put it on or arrange it. Asked if I would come over. I went over, I helped him do it. It was a great moment, one of the best moments we ever had. He even took his gear the way that I had told him how to do it, set it there, told his brothers and sisters not to touch it. That's the way his dad had placed it. Everything going good. I honestly don't know what happened. I did go for a couple weeks to take it all in. All of a sudden, after everything going so good, Parker doesn't want to talk to me. I call over and over. He doesn't say anything. I feel like he's being coerced, or he hasn't had an outlet. For 10 years, he didn't know who I was. She decided after 10 years, it was time to tell him, this is your dad. The guy you knew was your dad is no longer your dad. And it's been a back and forth thing. Anytime something good happens or we start to move forward, Parker and I in our relationship, it seems like she pulls it back in some way, or something just mysteriously happens. And we need the court's help at this time. I really hope for reunification counseling, everything that Mr. Lawrence has originally asked for. I would like the court's help in doing so, not only with counseling, but to use the court's app for communication. I don't recall what the name of that was.
Okay. Ms. Young, I think you wanted some input, particularly on the counselor issue.
Yeah, so Parker has Kaiser. Parker is 11 and a half years old and has had the same doctor. And Kaiser is perfectly capable of helping getting Parker into counseling. I have text messages showing where I've reached out to Stevie to try to schedule something, and he's, oh yeah, sounds great, and then nothing. He's called Parker one time. I also have my phone records of that. And this, I know his daughter's birthday was in the beginning of August. And after that, Parker was like, I don't want anything to do with him. And I've tried everything. And I even yesterday talking with Keith, I go, what more can we do to help Parker? As far as can Keith talk to Parker again and, trying to get as much help as I can. I think a school counselor is great just as another out for Parker. I don't think that's the fix all. I just want Parker to know that he's heard also. I'm glad that Stevie has all of this input, but there's no follow through. And I've got text and my call logs from Verizon to show that I'm sorry, but that's all a lie.
Yeah. So here's my take on this, and I want to brainstorm some solutions, but I do feel as if we're in a situation, Mr. Utter, where I think that you're failing to follow through with your obligations and blaming other people for it, frankly. Okay. So we need to get to a point where you're following through with your obligations and your child is feeling comfortable having that visitation with you. I think, and I'll turn to Mr. Lawrence for some help on this because you know more resources than I, but I think reunification counseling does sound like a good idea, but I know I'm kind of jumping into this case a little late in the game. I don't know if that's something that's already been tried and didn't work. What's your thought?
Your Honor, we had discussed reunification counseling. Parker didn't want to participate in it initially. He later indicated that he would be willing to do that. There's a lot of issues with Mr. Utter being out of his life as long as he was, and now trying to come back in. And I think that Kaiser could certainly provide reunification counseling and involve Mr. Utter as well. I think that would be a good plan. But the parenting plan appears to be pretty straightforward, and I don't understand when they put it together why Mr. Utter didn't understand that he gets to see him on Saturdays from, I think it was 10 a.m. to 6 p.m. or whatever it was, but that was written into the plan. And therefore, there's no need for any kind of permission to come and see your son. It's court ordered at this point. Mm-hmm. I don't understand that.
Your Honor.
Go ahead briefly.
This is not for me, my lack of trying. I too have phone records and text messages. This is not for lack of trying. This is strictly he didn't want to come over on those Wednesdays or Saturdays. I came to the courts. I want to. Why would I not want to now have a relationship with my son or not be there?
So let me ask Ms. Young, so we've got the temporary parenting plan, which does allow for that visitation with Mr. Utter. Are you asking for any temporary change to that? I think that my order today will be for reunification counseling, and then we'll review how that's going at our next date. But I don't know that it doesn't seem to me like this visitation schedule is working right now.
I think definitely get into counseling and I think Parker needs to be heard. So I don't know what this schedule wouldn't work. I don't think right now. I think it would be very forceful to Parker, if that makes.
Do you, as the custodial parent, I'll ask you this. What's your understanding as to Parker's comfort level with doing this visitation right now with Mr. Utter? Is that an issue for him?
Yes, he doesn't want to at all. And I don't, and like I said, I tried on 2 different Saturdays to have him meet up with Parker. I think counseling for all, or whoever needs to go, whatever the counselor, to try to get some help in this matter. Because I don't know I feel like I'm being forceful. Parker, you got to see him, and Parker's, tried with me and no luck. So I think we need help. And
that's what I'm asking.
And this, so Mr. Utter and Parker haven't seen each other since August. Is that right?
Yeah. And prior to that, it was, again, it's so sporadic. There's not a foundation here, I guess is the best way.
Okay. So Mr. Lawrence, I think I will do a bench order for reunification counseling. Do you have a recommendation for the court on what visitation should look like, if any, while we're going through reunification counseling?
Your Honor, usually when we go through reunification counseling, we leave that up to the counselor.
Okay,
The counselor will have an idea as to the status of the relationship and the comfort level of the parties, and can then make recommendations to both parents as to how to handle that, and whether to increase time, decrease time. You know, should it be video visits and telephone calls, or should it be in person? That the counselor really gets into the driver's seat at that point.
okay. So I think I will craft an order to that effect. I appreciate that input. So at this time, we'll set a review date here in just a minute, but at this time I am going to order that the visitation as laid out in the August 23rd temporary parenting plan is on hold pending reunification counseling and further visitation in this interim period to be determined by that counselor.
Okay.
Okay.
And then that's through Miss Young's insurance and Parker's doctor through Kaiser. And so I'll just wait.
That is an excellent question that I don't have the answer to. Mr. Lawrence, do you know?
Well, my experience with Kaiser is oftentimes they balk when it's court ordered. And if they refuse to do it, I don't know if Mr. Utter's insurance would cover, but the firm that I think is the most competent in the area is that of Charlotte Rosen and Mary Patterson. They have at least 4 counselors that are capable of providing this type of counseling. So if Kaiser doesn't do it, then I would suggest they go to that group.
Is that in Longview?
Yes.
Okay.
Your Honor, that's the same ones I've spoken to already, and they do take my insurance. That's
Okay.
what I've been trying to say from the get-go since we started this court hearing. And I've been trying to get them on insurance from the beginning.
Okay. So what I will do, I appreciate that further information, Mr. Lawrence. I'll craft that order. I'll leave it up to the parties if they want to try Kaiser first, or if they want to go directly to the other agency. How far out, I don't know how far out these individuals are booking for intakes on this type of thing. So I don't know if it makes sense to do a 30-day review, or if you think we might need a little bit longer than that.
Are you asking for my input?
Sorry, Mr. Lawrence. Yeah.
I would like to maybe see in 30 days where the status is as to which counseling agency and whether any kind of appointments have at least been scheduled.
Okay. So let's.
So is it my responsibility, Your Honor, or hers to do this? I'm sorry.
Well, I think it's a joint responsibility for a
I've
joint.
done this.
So you guys need to work together on this. That's part of the
That's
review
why we're here.
process.
We haven't been able to work together. That's why we're here.
Well, you gave me a joint proposed parenting plan that you both agreed to, and back on August 23rd, both of you said, we're fully on board with this and we're working
Absolutely.
together, and now here we are. What I'm telling you is you are both parents, you are both the adults in the room. Figure it out and get the counseling scheduled. I'm going to do the bench order, and we'll be back on November 1st.
Your Honor, if I could,
Go ahead.
I would suggest that Ms. Young try Kaiser first. And if that doesn't work, then Mr. Utter then proceeds with Charlotte Rosen's group. That way there's no back and forth on this thing.
Yep.
Everybody has a clear understanding of what the role is going to be right now.
Ms. Young, are you willing to take that task on?
Yes, I am.
Okay, so Ms. Young will go first with Kaiser, and then you'll communicate with Mr. Utter. If Kaiser doesn't work out, then Mr. Utter, it's going to go to you to reach out to the private group.
I'll reach out, but there's nothing I can do without him on my insurance. I mean, we're in the same boat.
Okay, I can't solve that problem for you. So you have my ruling. We'll see you back on November 1st.
Thank you.
Your Honor, can we get the text app through the court at least? So there is proof of communications and everything?
Are you talking about Our Family Wizard?
I don't know the name of it, but if that's what you guys call it, yes.
It's not through the court. You both are free at any time in your lives to sign up for Our Family Wizard. It does not need to be court ordered. You just download the app and you sign up.
Okay, that's different what the last commissioner had told us, but okay.
All right, we'll see you back on November 1.
Thank you.
All right, thank you both.
Oh, you're on to kill each other. It's like, all right.
This is your original
Okay,
motion
and
for
then-
contempt. Mr. Hansen has been given multiple opportunities to come into compliance. We signed the order finding contempt on July 19. And then we've had 1, 2, 3 review hearings. Okay, Ms. Hansen, you did, since our last review hearing, you did file documentation that he paid in August of 2023, but the July of 2023 was not paid. You're still owed $1,250 from July. Still, I believe, have not been paid from March to June. Is that correct?
Yes, that's correct.
Okay. So he is not here. He did yesterday drop off a document with the court. I am going to have the clerk put this in to the digital file. So I'm just going to read it out loud to you unless, did he give you a copy of this letter?
No.
Okay. It says, to whom it may concern, due to many unforeseen circumstances, I have missed 4 monthly court-ordered spousal payments to my ex-wife, Kimberly Hansen. Those unforeseen circumstances include lack of work due to contract negotiations between ILWU and the PMA. The contract has been settled and retroactive pay will be issued the pay period of October 24. I will pay all past due support plus interest as soon as the funds are in my possession. In addition to the above mentioned circumstance, I was involved in a pretty severe automobile accident on July 25th, where I was rear-ended while stopped at 40 miles an hour. I'm currently dealing with the bodily injury caused by this accident, as well as the fact that there are now even more limitations where employment is concerned. He has a segment, I don't think I'm going to read it out loud since we're live streaming, but it involves some health problems that his brother is experiencing in the hospital. He has started the process to petition the court to review support in the future as to reflect the rather large change in my financial circumstances since the original final divorce order. Once again, I assure you Kim will have her money the same day I receive it. I am sincerely apologetic for tying up the court's time in this matter. He is not here. This is the letter. I'll hand it back to the clerk for filing. What would be your request of the court today? I certainly understand you take a lot of time out of your day to come back to court for this. So what are you asking of the court today?
Well, I'm just frustrated that he has gotten away with it because he gets away with everything for 40 years. I watched him do that. He also went on a fishing trip for 10 days to Alaska for around the 1st of August. And I've watched him do that for 20 years in our marriage too. And I know how much it costs. And I also know how physically trying it is to go fishing on a fishing boat for 10 days. So him saying his wreck and all that, it's whatever. I don't know what else we can do, but I know by the time that he got thrown in jail, it'd be past October 24th, probably.
Yeah, your original motion and order for contempt did not request a jail sanction, so he wouldn't. We would need. You actually clicked does not apply on the jail time request. So I did find contempt. I ordered the back payment.
And how does interest work on the back payments? How do you calculate that?
So I'm looking at the contempt order and you did not put in a segment requesting interest. You left the interest column blank.
Yeah, because we thought it was going to just be 1 month and not.
Yeah. So what I would recommend at this point, I think probably the best path forward is I can certainly set a new date for review of this to after. Well, he says he's getting paid October 24th. We could set it 3 weeks out to the 25th, but you might want to consider filing a new motion in order for contempt that includes interest in case this keeps going. You're also welcome to then request in that motion jail time for failure to pay.
I'm really not interested in that. You know, I have 3 daughters that also, I don't want them to be affected by their relationship they're trying to have with him. And so
you want to well, so let's set this for October 25th and see where we're at. But why don't you at least resubmit with the interest request then?
okay.
And is it just that piece of it?
And is it just that piece of it? When I went up to the court to file the extra month, the guy had me filling out all the paperwork from the very beginning. And it really was just so which part do I need to fill out or submit?
So you would be, my understanding is you'd be filling out a new motion in order to show cause for contempt. That's not the clerk, just to make sure I'm right. Want her to do it as an amended. Yeah. Yeah. Why don't you do this, ma'am? Could she just do her original, take a copy of her original contempt motion and file it as amended with the interest inclusion? I always like to get permission from the clerks because they run the show here. So what I would recommend you do is just take your original motion and your proposed order that you filed back on or about July 19. And you'll see a column that says interest next to the $5,000 of past support that you asked for. Fill in that interest section go ahead. So fill in the interest section, and then up top, just call the contempt order and motion an amended order and motion.
Okay.
And then make sure you serve him with it. So it needs to be served on him, just like the original motion and order. And then I will set this for October 25th at 9 a.m.
Okay.
And then at that time, we'll do 2 things. We will review his payment from the original contempt order. And then I will hear any request you have to amend your original motion in order to include interest.
Okay.
Okay.
All right.
And then by that time, if he doesn't show, at least, file proof of service on me so I know that he has a heads up that you're requesting interest. So even if he's not here, we can move forward on that issue.
Okay.
Okay.
Yep.
Let's see, 25th. Yes. Okay. Thanks for your help on that.
So I went and checked my bank account the 1st of October and there was no support payment in there yet.
Okay.
So when he doesn't pay, I know we paid August, September.
Okay.
So if October, and then I've got to refile for October or.
Right. And that is the frustrating part with some of these monthly support contempt orders. But yes, you would file a brand new.
Like I did for July.
Say that again.
Like I did for July, just sent you new. Okay.
Yep. Yeah. It's a totally separate standalone contempt order for each month.
Right.
That doesn't happen. Or some people wait 3 months and they do a contempt order for 3 months. It's really your preference on that.
Okay.
Okay.
All right.
Okay. Well, hang in there. We'll see you back.
Okay, thank you.
And are you all still working with a GAL?
I don't think so. I don't know why, but I don't think so. She hasn't been involved for a while.
Yeah, I saw on my records, it shows we're still copying Ms. Day on this piece, but has she been removed on your end?
No.
Okay, well, I may have to dig a little deeper about the GAL involvement because it looks like it may be just fizzled out, but nothing kind of official. I have you guys on for, it says presentation of an order. Just looking to see, I did not see an order presented. I guess I'll ask you first, Ms. Fleischman, where we are at.
I'm not sure where that final order came in, but I think we're good with where we're at right now with Nathan. He just recently started a new job and, is working 12-hour shifts and his schedule changes. So, he reaches out when
when he's able to. But it was supervised visits with his brother. But I mean, I'm okay with his brother not being there. He's, you know, with his wife and her kids as well. So there's definitely other people around. But I think what we're doing right now, I think is something we should still continue to do until there's more of a set schedule.
Yeah, so I'm just,
Unless Mr. Smith has any, I mean, unless you have your schedule and you know, Nate.
My schedule varies. It changes all the time.
So that's the only hard part with having a set visiting schedule.
Mr. Smith, I know you all have been involved in this process for quite some time. So I am just catching up. Because of what we have right now appears to just be a series of orders regarding visitation, but no real parenting plan orders, temporary or final. I think you all originally came back to court on a motion to change a parenting plan. And we haven't made much headway in getting you all some finality. So what I would propose is that we start working on getting you all some orders in place rather than this hodgepodge of bench orders that we have regarding visitation. There's just so many orders regarding visitation. I think the most recent one I have is the May 8th, where we're allowing supervised visits every other Saturday with Brother Rob as the supervisor.
Yes.
And then public settings such as sports events are okay. Video visits continue, and then we were going to review it. And Ms. Fleischman, you're saying you don't need the brother to be a supervisor any further?
Yeah, I don't think it's necessary. Either, you know, Nathan's wife and her kids are around. You know, I don't feel it's necessary to bring Rob around. I mean, unless you guys still want to continue that, but I don't think it's necessary. You know, I'd like to give, you know, Nathan that chance to visit his son and bond with him.
I'm just going back to now to 2022, just to see if we ever had a ruling on the adequate cause motion.
I'm fine with the way the parenting plan is now. When Dustin wants to come over, he calls me. When I have my days off, I let Ashley know. I mean, I get to spend plenty of time with my son. We go fishing. We get to do all sorts of things. I attend his soccer games when my work allows me to. So.
Well, so kind of historically, you all have a final parenting plan. So the last actual true parenting plan, I know we've had a lot of bench orders about visitation, but the last true parenting plan was from 2019. And then in 2021, the end of 2021, you both filed motions for adequate cause to change that parenting plan.
Yes.
Are you?
Apparently, in 2019, I was incarcerated. I was served that in federal prison.
So right. So my question is whether you both, if you're both in agreement that there is adequate cause to change that 2019 parenting plan, then what I need to do to kind of clean up this file a bit is to enter an actual order finding that you both agree there's adequate cause to move this case on for finalization of a new parenting plan. And then you two can either work together on a proposed final new parenting plan, meet with our courthouse facilitator, get all the ducks in a row and present that order to me. Or we can talk about things like the two of you going to mediation to help craft the new parenting plan. So first, let me ask you, Ms. Fleischman, do you want me today to enter an order finding there is adequate cause by agreement to start down this process of creating a new parenting plan?
And when you say, I'm sorry, I guess I'm just confused because all of the orders afterwards. So I'm kind of lost in like what's the parenting plan and what's not.
So you only have one true final parenting plan from 2019.
So when I
Now,
submitted that, you
hold on one second. You do have subsequent bench orders where a judicial officer has changed visitation, but
I
those
see.
are all temporary. What we need to get to is if you both agree there needs to be a new parenting plan since 2019, let's put all of that in a new parenting plan order versus all these little bench orders.
I see. Then yes, I would like to do that.
Okay. Mr. Smith, do you agree with that?
Yes.
Okay. So what I'm going to do after docket today is issue a formal order that by agreement, you both find that there is adequate cause to revise the 2019 parenting plan. And then my question to you is, do you all believe being referred for mediation services would be of benefit to you? Or do you believe the two of you are in agreement enough on what the new parenting plan should look like that you can do that on your own?
I think
Yeah, I
we're,
think we could do that on our own.
and if not, I mean, am I able to, I don't know what the correct wording is, but put a motion in for mediation? Is that how it works?
Yep. So why don't we do this? I'll do the adequate cause order. We'll set a new hearing date for whatever time, however long you guys think you need. But please know if you guys do come to an agreement on what the final order should look like, you do need to meet with a courthouse facilitator here at Cowlitz County Superior Court before those orders come to me for review.
Okay.
So I want to give you enough time to get that done. I'm kind of thinking 6 to 8 weeks.
Okay.
So do I got to fill out one and she has to fill out one? We both go together, or
You can
are
do
we
it.
filling out just one together?
If you're in agreement, do it together. If you're not in agreement, then you each would propose plans to me or come back to me in 6 to 8 weeks and say, hey, we can't agree. We want to be, one of you at least wants to be referred for mediation, and then I can consider that order.
Okay.
Sounds good.
Okay. So what about November 29th?
Okay, that works for me.
Okay, at 9 a.m. And then will you remind me the process for them to see a courthouse facilitator? They come in and make an appointment, right?
They have to come and make an appointment. Whoever signs the disclaimer has to be present at the hearing, and it's $20, and we need their final first.
Okay, so when you all are ready to have your orders reviewed, assuming you have an agreement, come to the clerk's office here, pay $20, and they will get you an appointment with a courthouse facilitator to make sure you have done all the paperwork and it's ready for my review.
Perfect.
Can one of us make that appointment, or we both have to be together to make that appointment?
My understanding is the person who makes the appointment has to be at the hearing. I assume you both will be, but one of you, yeah. And then if you don't come to an agreement, that is okay too. When we come back, we can talk about areas of disagreement and whether mediation makes sense for you all at that point.
Okay.
Okay. All right, I will get that order signed. We'll see you back on November 29th. So I have this on from my understanding, essentially 2 motions for contempt, I think filed by one by each of you. Do we have service of the motions in order from Ms. Marquez to Mr. Sekni now?
Yeah, I got them on the 18th, so it was about a week and a couple of days after we had court, the last date.
Okay. And then Mr. Sekni, you have filed your motions on Ms. Marquez as well?
Well, I filed my motions for my contempt. I didn't, however, file a response to hers.
Okay.
And there's a couple of reasons for that. One of the major reasons are she came over to my house on Wednesday of last week, which has never been something that has been offered or agreeable upon the two of us. And we came to kind of an agreement about a lot of the things that we have filed that we were not understanding.
Okay.
And so I think we're on the same page for a lot of it and most of everything that we have both filed on each other, but we're not really sure what to do in order.
Okay.
go that route, I guess, because she had an attorney before and now she doesn't. So we're kind of on our own grounds again.
I did see that. So let me ask for you, I guess, Mr. Secney at least, and then I'll go to Ms. Marquez. Are you at least at this point wanting to strike your contempt motion against her with the understanding that you believe she's going to strike the motion for contempt against you?
Absolutely. Yeah. That was the agreement I'm understanding when she came over. We had about a couple-hour conversation. And
okay. So let me go to you, Ms. Marquez. Does that sound correct to you that you're both kind of mutually agreeing to strike for now your contempt motions?
Yes. So everything involved in there, for the most part, I do want some sort of agreement that when he can or he's able to pay the amounts that he owes, that he does pay them. Other than that, I'd like to strike everything else further.
Okay. So let's talk a little bit about that. So what I will do is strike the actual contempt motions, but what is still an outstanding issue on for review of this court is past due childcare expenses, it sounds like. Is that right?
Yes.
Okay. So Mr. Secney, what have the two of you come to an agreement on how you're going to handle payment of the childcare expenses, your portion?
so basically we were kind of feeding off of more hearsay about one another and what financially one another were doing. And we don't really communicate. We kind of, my fiance does most of the communicating just because it hasn't been great in the past.
Okay.
And I think we're going to kind of move forward through that. But what I offered and proposed was that my son and my other stepson go to a different daycare, which is way more financially accurate for all of us. And that's my biggest issue is I'm paying child support and I have 2 other kids and, I'm just not making ends meet with the childcare, and we lowered it from 63 to 50, which I thought was going to be doable at some point, but I have just now finally kind of got back where I should be, and I'm going to start making payments with the daycare so that she doesn't have an outstanding balance. However, we decided we would just split the $20 days where she will be going to daycare present when that time does come so that she can look for another job and the daycare issue doesn't resolve back to the same problem we've had 2 times now.
Okay.
We were paying she was paying almost $2,000 roughly every month. And some of the charges on there we discovered sitting down together weren't accurate. They're not correct. They're overcharging me and they're not charging her the exact same amount, which it's supposed to be 50-50. So we need to come together and go to the daycare and figure out what went wrong before I pay any money.
Okay. So let me ask Ms. Marquez, since this was your initial request, if you all want court involvement on how to handle this, what I would recommend is setting a new review date and having you both propose this sort of arrangement, or I could simply let the 2 of you, it sounds like maybe you're close on how to figure this out. Let the 2 of you deal with that. You could renote it on this docket if you need court involvement.
Okay, so
go ahead.
yeah, that works. But so let's say in a few months, Spencer just decides he doesn't want to pay it all or he can't afford something comes up. When setting the review date, would I just get another date for contempt or?
Yeah. What I'm going to do on your order for contempt is I'm going to say that it's denied without prejudice. What that means is for now, you both have agreed to deny the orders for contempt. Without prejudice means you can always re-raise it.
Right. Okay.
Okay. So what you would do if we go ahead and all we do today is deny the 2 contempt motions, you 2 have some time to work on it. If you can't come to an agreement, then you would just renote a new contempt motion, Ms. Marquez, and then I could decide the issue for you.
Okay, sounds good.
Does that work for you?
Yeah.
Okay.
Does that apply to both parties or just the one that filed the motion first?
Well, yours I can also issue without prejudice.
I think there's some valid things I had in there that I still want to be addressed if issues do come up, which, like I said, I think we're on a pretty understandable agreement right now.
So both of your contempt orders will be denied without prejudice, meaning if you all can't come to an agreement on these issues, you can re-raise them with the court.
Okay. Thank you.
Okay. And then, so we won't set a formal review date. But if you need the court's involvement, please go ahead and either party can renote for any Wednesday 9 a.m. docket.
Okay,
Alright.
sounds good.
Okay. All right. Thank you
Yes, I'm
both.
here.
Thank
Okay.
you.
And do we have
Thank you.
Sammy Landon? Don't see anyone. There's no one in our waiting room on Zoom. My understanding, Ms. Ramirez, is that you did meet with the courthouse facilitator for your final orders, which I do have in front of me.
Yes.
And that you did have the court facilitator review them. My understanding also is that on August 10th, an order of default was signed by Judge Fassett here in our Superior Court because of Mr. Landon's failure to appear or answer.
Yeah.
And so are you asking the court to enter your orders today?
Yes.
Okay. Do you have any questions for the court before I do so?
I just have a question with the whole custody with my girls, and also would I be able to get a passport for them?
Sorry, say that last part again.
Would I be able to get a passport without Sammy?
Let me see what you have listed in here. Typically, you will need both parents to be present to apply for a minor's passport. Are you submitting child support orders?
I already have child support through the what is it called? Through the child support.
She has what? Yeah, you haven't proposed any child support orders to me.
Yeah, I already have a case open.
So when you need like somebody email the state and they tell us.
Oh, so the courthouse facilitator would have already looked into that. And that's probably why I don't have orders, because I do see you put a case number in
Yes.
here with the state. Okay. Okay. So back to your question, I don't believe I have any authority to change essentially, which is a federal requirement that both parents be present for a passport. I think the exception to that is that the other parent can supply a document that waives their personal appearance when you go apply for the child's passport. And I think
in there would I be getting like full custody?
we are putting a hold on, we're putting a restraining order into place. So at this point, what I would do, it's not going to be up to me. It's going to be up to the federal government as to what they're going to require. So I would just recommend that when you go in person for an appointment for kiddos, that you bring these documents with you, including the restraining order that I'm signing today.
Yeah, because I went in there like a few weeks back, but I didn't have the parenting plan submitted yet, through you guys yet. So I think that's what he told me. Once I'm done with the court, I could just bring the final order. Because I haven't talked to him or anything.
Yeah, I think that, I think that's going to be your best bet, and I would probably recommend, I know you can do the passport applications at post offices, but I would probably recommend that you go to an actual Department of Homeland Security office, because they are going to have probably a little more leeway to look at these documents and decide what they might need from you. And I'm just saying that based on my personal experience of having applied for children's passports at post offices.
Okay.
It's pretty, they don't have a lot of discretion to do much except stick to the rules. So if you go online to the Department of Homeland Security, they'll list the closest actual office.
Okay.
Okay. So I've signed these for you. If it does turn out that you need something else from us for passport purposes, once you talk to Department of Homeland Security, feel free to renote a motion in our court if you need something further.
Okay, so by today, I have full custody of my babies, right?
Yep, I have signed your parenting plan. I've signed the restraining order. Yep.
And I'm divorced.
You are divorced. I have signed your final orders.
Oh my God, thank you so much.
Yep.
So
Okay.
I can pick up the copies today, tomorrow?
I would say by this, could she get copies this afternoon? Or tomorrow's better?
I'll go tomorrow. Keep you guys time.
Okay, and there is a cost to that for getting the copies. So
That's fine.
hopefully that doesn't take you by surprise. Okay.
No,
All right, thank you.
thank you.
On
Have a good day.
this case-
No,
Yes. Oh, did someone ask a question? Shoot, your audio is cutting out really bad. I can't hear you again. Can you try turning off your camera? That should give you better bandwidth for audio.
No.
Okay.
Can you hear me now?
Yes, I can.
Okay.
Did you want to ask a question?
No, that wasn't me. It was somebody else's name that flashed up on the screen.
Oh, interesting. Okay. So here's what I show on your case, ma'am. Jeremiah Unasa is not present. There was an order of default issued on May 17th in this case, giving this court authority to issue final orders without his notification or presence. You met with a courthouse facilitator who has indicated that the final orders that you're asking me to sign are ready for review. Is that your understanding as well?
Yes, that's correct.
Okay. Do you have any questions before I sign these orders?
No, she did such an amazing job. She went through everything with me. And I was hoping it would just be simple and straightforward.
Yes, I'm really glad that you found the courthouse facilitator helpful. I think it's such a great resource, and it certainly makes my job easier.
She's a pro, let me tell you.
Oh, good. So I have signed your first two orders, the divorce order, which is your final dissolution order, the findings and conclusions about a marriage. I'm on to the parenting plan, and I'm just going to put on the record that I am adopting your recommendations that I find 3A limitations on behalf of respondent. I am finding under child abuse enough evidence for repeated emotional abuse and domestic violence. I am also finding under 3B that respondent has engaged in abusive use of conflict. Because of those limitations, it appears that we are going to and have to limit contact with the child at this time. It will be a non-professional supervised or supervisor who has to be present anytime there is visitation with the child. I'm also indicating that you are the sole decision maker on school, educational, and healthcare because of the limitations that I have found applied to respondent.
Okay.
You are the custodial parent. It looks like the supervisor is Edward Wortanen.
Yes.
Okay, and you still are comfortable with that individual?
Yes.
Okay. So I'm going to go ahead and sign this document. I will just note for the record that respondent is not present, but that is to be anticipated. And then my understanding is for child support, that the child does not receive any sort of state assistance.
As far like TANF, we are on food stamps.
So let me just check. So when the courthouse facilitator would have already dealt with whether the state would need to be involved for child support orders.
She said no.
So you guys did talk about that?
Yeah, we did.
Okay, we're just going to take a quick look because typically where there are food stamps involved, the state may have some involvement in crafting the child support order.
It was verified in 2019 that the state was not involved.
Okay, perfect. The clerk has verification from September 19th. The state is not involved in this. So I will go ahead and sign your proposed orders. Just getting here to the end, and then you should be done with us. Just making sure we've got everything checked. I will sign this order. Any questions for me?
No. Thanks,
Okay.
but not
Okay, well, we have got these orders signed. I'm going to hand them up to the clerk, and then you are welcome to get copies at any time. There is a charge for that.
Okay, do you know off the top of your head what the charge is?
I will find out. Do you know what the charge is?
For a certified copy, it's $5 for the first page and roll for each additional page. After that, each document, the warrant is 50 cents per page cash.
If it's not certified, 50 cents a page. Okay, so 50 cents, if you don't need certified copies, it's 50 cents a page. If you need certified copies, it's $5 for the first page and then $1 for the additional page, each additional page of each document. Cash only.
Okay.
Okay. All right, thank you. You're free to log out.
Okay, thank you.
Yep, you're welcome. And I think that ends our docket.